want to prove that it's yours, whether it's an invention idea or a copyright idea. Mail it, seal it in the envelope, even sign your name on the back where the seal is. Okay? Get another envelope, mail it to yourself. Don't seal it. Don't put anything inside it. Mail it to yourself as well. Okay? When you get both envelopes, fold up a copy of your idea or copyrighted work inside it, seal it, and sign it. Do you think anybody's going to be able to tell the difference? That's why it doesn't work. It just doesn't work. Mailing it just doesn't work. You can't tell the difference. If I were going to show a third party those two envelopes, they both have the U.S. Post Office stamp saying when they were mailed. Okay? You can sign them. You can testify that this is the way I did it. I mailed it to myself. I had signed it before. But basically, there's no further proof. And there's no way for a third party to tell the difference between the two.
I was just going to say, what about notarization?
What about a notarization? What are they notarizing? The sealed envelope?
No, not doing the mailing thing. Just
Oh,
taking your
notarize.
and having
Establishing, okay. When you begin to get other people to sign off on a document, you start to establish some corroboration. Okay? So that's something important when they're corroborating what's on the document. In fact, for patents, when you're trying to prove something, it's always best to have, and you want to sign your name to a lab notebook or something, it's always best to have somebody else sign their name to that lab notebook page. Okay? That's corroboration of what you've done. So yes, adding more people to that list of people who are looking at that document and signing and dating it does help. But mailing something to yourself doesn't.
What about the computer? I was recently told that you send an email to yourself because we'll have a time and a date on it.
Well, I will tell you something. I'm not a computer expert, but I have a friend who is, and he has told me he can send me an email with any date he wants on it. Okay? He can even send the email from any address that he wants. He's involved in the internet security stuff. It's way over my head. So please don't ask me any questions about it. In spite of Susan's challenge that we can answer any question. I don't know anything about that. Okay, well, I'm going to go ahead and move on. You've seen this before. The U.S. Constitution. We are very fortunate in this country that those who founded this country thought that intellectual property was important, that it was important to the foundations of this country. And so they put it in the Constitution, very specifically. Not only did they put it in the Constitution as an opportunity to protect these rights, they actually told Congress, and I believe it's the only power that Congress was granted, that told Congress how to implement it, to promote the progress of science for the useful arts by securing for a limited time the respective writings and discoveries of authors and inventors. So it's very important in the fabric of our country. Innovation is very important to the fabric of this country. And I think we have a very clear tradition that we can continue to keep the United States competitive. First of all, what is a patent? I apologize. How many people in here either own a patent or are a patent attorney? Okay. So quite a few of you. I'm actually speaking to the choir here. An awful lot of you already know patents. You've already been involved in patents. So I'm speaking to the choir, so forgive me. Patent is basically a property right. It's not a right to use anything. Okay? The government still could say, no, you can't practice your invention. A good example is in the pharmaceutical field. Food and Drug Administration can say, no, that's not safe, that's not efficacious, you can't market that invention. Okay? You get the right to exclude others from your property right. Okay? It's like a fence around your property. You're saying, nobody else trespass on my property, okay? At the end of every patent is something we refer to as claims. The claims are the words that describe the scope and protection that you want for your invention. It is the fence that I just mentioned. It's for a limited term. As I said, the Constitution said limited term, okay? It's been decided actually very universally around the world that that limited term should be 20 years for a utility patent or a patent on a functional invention, okay? So it's a limited term. Territorial, as was said in Eve's presentation, a U.S. patent is not good outside the United States. And there's actually an exception. U.S. patents are actually good in Jamaica. It's the only exception. U.S. patents are not good anywhere else. U.S. trademarks are not good outside the United States. Right? There's no world patent today. We in the U.S. government believe that it's in business interest to try to get a worldwide patent, and we certainly are taking steps to try to harmonize patent law. As you might imagine, with 197 countries around the world, it's not an easy negotiation. And we're still working on that. We spend a great deal of time working in that direction. A patent is an exchange. Patent is an exchange between the public and the inventor. In exchange for a disclosure of the invention, and not just any disclosure of the invention, a disclosure of the invention that will enable those skilled in that technology to make and use that invention just by reading the document. Okay? In exchange for that, you have the opportunity to get a patent. I don't say you get a patent because you file, the application may be published, and you may not get your patent because it didn't meet